All right, our last chapter of the semester is Chapter 14, Juvenile Corrections. The three main governmental agencies that encompass the juvenile justice system are the police, we've already talked about them, the juvenile courts, which we talked about as well, and the juvenile correctional system, which we're going to visit right now. Of these three, the juvenile correctional system in the U.S. is the most diverse and unique. A whole host of facilities, programs, and processes exist to deal with at-risk juveniles, delinquent juveniles, and juveniles who are under some type of court sanction. There are a multitude of public and private correctional agencies and social service agencies that deal exclusively with juveniles. In addition, from state to state and county to county, there is a wide variation in terms of the number and kinds of correctional services provided for juveniles. However, these can be divided into two categories: community treatment and institutional treatment. Community treatment refers to efforts to provide care, protection, and treatment for juveniles in need. And there are a number of examples, including probation. We'll talk about these specifically. Treatment services such as individual and group counseling, restitution, this is paying back the victim in some way, foster homes and small group homes, boarding schools, counseling, whether it be individualized or group counseling, just like the treatment services, and vocational training. The key is that the juvenile corrections mode of community treatment involves using non-secure and non-institutional residents to rehabilitate juvenile offenders and resolving the problems of juvenile. So institutional treatment involves using secure and institutional residents to treat juvenile offenders. Correctional centers are operated at the federal level, the state level, and or county governments. We can have a combination of those. And generally, they restrict movements of residents through means such as staff monitoring, locked exits, fencing, just like how a prison would appear. They have various types of treatment from different types of reception centers, specialized facilities, training schools, ranch and forestry type schools, as well as boot camps. Studies of the effects of correctional programs or institutional treatment on juvenile delinquency have observed that delinquents exhibit a sharp rise in their arrest rates up to the time of intervention. The drop to a lower rate following intervention has been labeled a suppression effect. And a controversy has arisen regarding the nature of the suppression effect. Some scholars attribute it to the effectiveness of the correctional programs, while others claim that it's due to their selection process. Nonetheless, choosing the proper mode of juvenile corrections is difficult. Some experts believe that community treatment is the route to go for any hope for rehabilitating juvenile offenders. So the justice system, courts, they must carefully choose the outcome it wants to achieve. What does it want to achieve? Does it want to prevent delinquency, or does it want to achieve the care and protection of youths in need? So let's talk about the most popular component of community treatment. The juvenile court is the centerpiece of the juvenile justice system, and the juvenile probation department is the operational arm of that centerpiece. Most juveniles who are formally processed by the juvenile justice system end up on some type of probation. Probation is a sanction where the court releases a youth to a parent or other guardian to live in the community under certain rules and conditions, and those are set by the court. The court sets those conditions. These rules and conditions attempt to balance the need to protect society with what is in the best interest of the child. because that's what the judge has to consider, what's in the best interest of the child. This is a non-punitive legal disposition emphasizing community treatment with close supervision. Juveniles placed on probation, like I said, under certain conditions, and generally they can include reporting to the probation officer when required, attending school, curfew restrictions. We'll talk about more of those in a little bit. Could be requiring treatment. So how did community treatment probation develop? The roots of community treatment can be found in England, where specialized procedures for dealing with youth offenders were in place as early as 1820. Juveniles were sentenced to prison for one day, and then they were released to their parents. John Augustus, who's been claimed the father of probation, is recognized as the first true probation officer. In 1841, John Augustus attended police court to bail out an adult who was a common drunk, who became the first probationer. The offender was ordered to appear in court 3 weeks later for sentencing. He returned to court a sober man. He was accompanied by Augustus. To that astonishment of those in attendance, his appearance and demeanor had dramatically changed. Augustus thus began an 18-year career as a volunteer probation officer. Not all his offenders were adults that he helped. He personally monitored youths age 7 to 15 up until around 1847. Actually, that started in 1847 and continued. In 1869, Massachusetts formalized a probation process when the Board of State Charities commissioned agents to act for the board in juvenile criminal matters only. And by 1890, probation became a mandatory part of the juvenile court system and the court system in general. It was adopted into the adult courts as well. The rapid spread of juvenile courts during the first decades of the 20th century encouraged the further development of probation. By the mid-60s, juvenile probation became a very complex institution. With juvenile probation, youth could be rehabilitated, and the public became responsible, or was responsible, for protecting. So probation now, contemporary probation, as I said, probation is considered the backbone of community treatment for juveniles because it is the most popular juvenile disposition for juvenile court judges. 339,700 juveniles were placed on formal probation to date. Why is it? What is it, I should say? What is probation? Well, first, it is a direct judicial order that allows youth to remain in the community under the court's supervision. So this also means that the court stays involved with the youth's case and can tailor terms and conditions as needed. They remain in control over the case. The key for this is rehabilitation. Rehabilitation is favored over incarceration, even for the serious violent offenders. So what results? What happens? So this becomes a contract between the juvenile and the court, being on probation. The contract consists of terms and conditions that the offender must abide by. Common rules include don't get arrested, meet with a probation officer at times set by the probation officer. I have more terms outlined here more specifically, and these are general terms. This is what there's generally a set of general conditions that everybody who's on probation has to follow. Be employed or go to school, take care of family responsibilities, curfew, rehab treatment, counseling, maintain a residence within a family setting, i.e. live with your parents or guardian, refrain from associating with certain types of people, i.e. generally that means other people who might be delinquents or been on probation or have their own criminal problems or delinquent problems. remain in a particular area unless given permission to leave. Basically, stay within the community of what you're being supervised under, or where you're being supervised. The court can impose the requirement to make payments to the victim. And then not only do we have general conditions, it can be specific. The court can also set specific conditions that are crime related. If something involves a domestic violence case, the court can set conditions relative to treatment in, anger management or domestic abuse. If it's a sex offender type case, a sex offense, there's treatment and specific counseling for that, and the judge can, narrowly tailor that. I've seen restrictions that say you can't use the internet, you can't use social media, or it has to be monitored in some fashion by probation. What the terms cannot be are cruel, and they can't be beyond the capacity of the juvenile to understand or comply with. If a juvenile fails to do of these terms or violates one of the terms, say they're rearrested for another crime, they don't go to treatment, they face termination or the revocation of their probation term, and the court can sentence them, i.e. incarcerate them, to being in a secured facility. The judge will have a hearing and a resentencing to determine what the outcome should be. Sometimes there's a continue on probation, and the court can extend the time on probation. The court can sanction. You know what? I think you need a day and a night in a secured facility, i.e. to get a taste of it. I've seen that happen. And then they return to probation. The court can just terminate and send the juvenile to a secured facility. For how long? Depends on the conviction of the crime. It also depends on the age of the offender. The probation sentence and terms can vary from state to state, and it depends on the seriousness of the offense, of course. At this hearing process, the juvenile is entitled to having a hearing, meaning to be heard relative to what the violation is, and they're entitled to have an attorney to represent them. The justice system continues to have confidence in rehabilitation, while also accommodating demands for legal controls and public protection. So what that entails is when the court is determining, even at the revocation stage, not just at the dispositional stage, the justice system, one, what's in the best interest of the child? We're going to focus and have confidence in rehabilitation first. But also, when they're outlining their conditions, they have to take into consideration the control over the juvenile and how are they, the court, protecting the public. So let's talk about our probation officer. It's a lot different than an adult who is on probation. Yeah, generally the adult has a probation officer that they have to go and see when the probation officer says that they have to go and see them. Same thing with the juvenile. But the juvenile probation is right involved from the beginning, not like adult probation. That doesn't come to play until the end of the case, when the judge is making some sort of determination on a sentence. But for juvenile probation, the probation officer is right at the beginning, the intake process, as we discussed. So we have 4 stages: the intake, predisposition, i.e. the case is pending, post-adjudication, that's after a finding by the court, and then we have post-adjudication, that's after the sentence disposition is handed down. We have 4 stages where the probation officer is involved. So the intake, what do? They screen the complaints, and they make case decisions, referrals. They refer the child to agency for services or to the court for judicial action. If the court action then is the next step, we have predisposition, where the probation officer participates in release or detention decisions. They may make a reference, a referral that the child remain with their parents. They've done the investigation for the court and have information, whether they can determine whether there's treatment available in the community. So they're involved with assisting the court on whether detention should be maintained while the proceeding is pending. They may advise the court, like I said, of the child's home life or suitability for remaining in the community and what other non-detention setting is available. Then our next component is the post-adjudication. So now the court, this is the assists the court in reaching a dispositional decision. So we've already have the judge had a trial, or maybe the child admitted to the crime. So we are after adjudication, but we're before the judge hands down the decision on what to do. So probation then is involved with assisting the court on whether what's going to happen is then they're going to help the court reach a dispositional decision. How do they do that? They prepare dispositional reports, the predisposition reports containing information, pertinent comprehensive information regarding the juvenile, which could be about their family life, their school life, their health, their work history, their medical history. Sometimes during this time, the court may direct that supervision take place before the court actually makes a decision, so the court can get an idea how a juvenile will do under supervision. Once a juvenile is adjudicated a delinquent, and the probation department's role in the life of the juvenile increases substantially. So now the judge has determined, or the court has determined, that the juvenile gets placed on probation, and we have post-disposition. What happens? They supervise the juvenile who's placed on probation. They provide supervision and treatment in the community. They provide extensive counseling to the child and family. They refer to the appropriate social service agencies, could be both child and family. They have to report back to the court on the progress of the youth and how they're making out on probation. And it's usually done in the form of a hearing. So then they present a further updated report, and the child is present and generally present with the attorney, their attorney. Juvenile probation officers' caseload vary by location as well as by demographics of who is on probation. And a national survey of juvenile probation officers revealed that they thought their optimal caseload was 30 juveniles, while their actual caseload was 41 juveniles. A number of variables can affect the caseload of the probation departments and individual officers. Obviously, the number of referrals from the juvenile court is the prime determinant of the size of the caseload. Other factors can include resources, what's available, the turnover, management within the probation department itself. In some probation locations, if it's a smaller area, the probation officer may be supervising both adults and juveniles. In bigger areas, bigger cities, more urban, they might have might be supervising just juveniles. In Clinton County, there is a specific probation officer that only supervises the juvenile offenders. So Probation Innovations. Whenever a juvenile receives a disposition from the juvenile court, there is almost always a term of probation assigned to that youth. While the probation sentence is common, there are a number of other community correctional alternatives that a judge may choose to impose. In addition, there are a number of variants to standard juvenile probation that focus on increased supervision, increase security and control, and increase treatment and counseling. Each of the variations in juvenile probation has become fairly common in the U.S. over the past 25 years. And one of the types of alternatives that a court can impose is not only probation, but an intense level of probation, juvenile intense probation supervision, or JIPS. Sometimes it's just called IPS. It increases the level and the amount of supervision of juveniles in the community. They are characterized by high levels of contact and intervention by the probation officer, who is seen as a more or less a caseworker or counselor. They have smaller caseloads, and they have strict levels of compliance. They are tasked with treating juveniles who normally would have otherwise been sent to secured confinement in the community as part of a small, specialized caseload. The goals are to keep them out of overcrowded facilities. Other goals are to control them with strict supervision, sometimes including tracking them. We'll talk more about home confinement and GPS and electronic home monitoring. Keep them in school, maintain community ties, and allow them to complete their education and stay within the community to maintain their family and social relationships. But they're very strict supervision, probably daily interaction with their probation officer. So the question is, does it work? Does intense supervision work? Some say better than regular probation monitoring, and it saves, of course, incarceration costs. However, some say there is a high failure rate on ISP, which doesn't seem to be a surprise because these individuals are the most serious offenders. They're even chronic offenders. And now they're subject to being watched very closely, meaning that they get caught violating their terms because they are under a strict supervision that they're not used to. On the other hand, research found lower rates of repeat offending among juveniles who received ISP versus a comparison group that did not receive ISP. Other studies have found no significant difference between juveniles that went through ISP versus those that did not. Let's talk about another alternative, electronic home monitoring. It's another option for community treatment. And generally these types, what we're going to discuss next, we talked about probation, general regular probation. We upped it to intensive supervision probation. The things we're going to talk about next are usually a component of probation. Can the judge sentence them on their own without probation? Absolutely. But generally they are part of probation. One of those is electronic home monitoring. While a juvenile commits a serious offense or is thought to be a security or flight risk, a judge can order that a juvenile stay at home under house arrest. This order can be given while the juvenile is awaiting adjudication, while the case is pending, or as part of the juvenile's probation plan. The idea is simple. The juvenile is not permitted to leave the home for any reason other than school, work, court, or treatment programming. The juvenile is monitored by home visits by the probation officer and random phone calls from the probation department. The juvenile is placed on a schedule by the probation department and must be where he or she says he or she is supposed to be at any given time. In addition, a juvenile who is placed on house arrest must be monitored by a parent or guardian at all times. Parents and guardians will typically sign an agreement not only to supervise the juvenile, but also to report any deviation from the treatment plan or unauthorized absence from the home. If they fail to report the juvenile missing or fail to supervise him or her, they can be subject to a contempt of court citation and incarcerated. House arrest is frequently for a given amount of time at the beginning of a juvenile's probation or in response to a juvenile's failing to follow the rules of probation. While a juvenile is judged to be an increased security risk, like I said, by the probation department or the court, another option is for the juvenile to be placed on electronic monitoring. The process of electronic monitoring operates in juvenile justice in much of the same way as it does in the adult criminal justice system. The juvenile is fitted with an electronic monitoring device. It's usually attached to their ankle. The device typically works in conjunction with a monitoring system that is located in the juvenile's home and connected to a phone line. Although the specific systems vary, the operating principle is basically the same. Once a juvenile who is wearing an electronic monitoring device gets outside the device's range, an alarm sounds, and the probation department is called, and they're called by electronically called, not the telephone rings. Side note, Martha Stewart, I know this is a way side note from juvenile delinquency. Martha Stewart had electronic monitoring, and her property was so large when she was walking her property, she would set off the electronic monitoring as it got outside the scope of the range. Although, like I said, they vary. Let's see, recent technology advances in GPS have eliminated the home monitoring device. So what happens is the juvenile is now monitored by a satellite. The rationale of this system is to assure the probation department that the juvenile is where he or she is supposed to be without a 24-hour-a-day monitoring with the probation officer. There are other alternative sanctions that use a means to hold juveniles accountable outside the traditional mechanisms, such as probation and incarceration. Interestingly, most often these sanctions are not used as an alternative, but in addition to probation and incarceration. As such, some critics point out that they are anything but alternative and are simply a means to place additional sanctions on juveniles. One of those is restorative justice. We've talked about this component. Focuses on the three interrelated components of community safety, competency development, and accountability. The later component implies accountability to the individual victims of crime, not society in general. As such, this model and other accountability-based laws focus on such sanctions as victim offender mediation, restitution, and community service. And I'm going to touch on those three. I'm going to expand on those three. The role of victims in the criminal justice process has increased substantially in recent years. There are several mediation programs for juveniles that have started around the country. These programs attempt to bring together juvenile delinquents and their victims to mediate the situation between the parties. In some instances, this is used as a diversionary tactic to keep a juvenile offender out of juvenile court. Other times, it's done in addition to probation proceedings or as part of the juvenile's dispositional plan. In some jurisdictions, the mediation takes place under the guise of the juvenile court or through the juvenile probation department. In other jurisdictions, the mediation is done through a private or public mediator or mediation program that receives direct referrals from the juvenile court. Most often, the cases referred involve property crimes, minor assaults, and other minor offenses. Both parties, the juvenile and the victim, must agree to participate in the mediation, and the mediation session is typically run by a professional mediator or court representative trained in victim offender mediation. The mediation typically involves two phases or two separate meetings. In the first part, the victim expresses his or her feelings directly to the juvenile about the crime, and the juvenile can attempt to explain his or her actions and motives for the offense. In the second part, the actual losses the victim incurred are discussed and documented, and a plan is developed for compensation by the juvenile directly to the victim. These programs are becoming very popular, and most juvenile courts in larger jurisdictions now either operate a mediation program or can refer cases out to mediation. Another component I want to jump down to restitution. This is another key component. Popular alternative sanction in juvenile justice is restitution. Restitution is like I said earlier, the payment of money or the rendering of restorative services or work to the individual victim of a crime, either a person who may be either a person or a business. The victim will report the total amount of loss to the court, and the juvenile offender is then sentenced by the court to repay the victim for the losses. Most often the payment is in cash. However, it is also fairly common for the juvenile to work off restitution for the person or business directly. For example, in a vandalism case where a juvenile caused property damage, the juvenile would be sentenced to repair the damage he or she caused under the supervision of the victim or the victim's representative. Juvenile court judges around the country have been very creative in their restitution orders. There are documented instances where juveniles have been sentenced to repaint houses, landscape properties, brand cattle, and even wash cars and dogs for their victims. Some judges find a dual purpose of restitution that can be both a restoration for the victim and an embarrassment for the juvenile. Some problems exist with juvenile restitution. For example, chronic juvenile offenders. They can accumulate quite a hefty sum of owed restitution, and in many instances, the victims will receive restitution in an amount sufficient to cover only their insurance deductible, with the remainder of the restitution being owed to some insurance company. Also, it could be very unlikely that the restitution sentence is ever paid off, because the only type of work or job that a juvenile could get is, minimum wage. And if we're talking about extensive property damage, that's large, and that's pretty common, that restitution doesn't get paid off in the end. Let's talk about, before I jump into these last few here, it's not in the book. I don't know why it's not in the book, but it's extremely important and it's extremely common. Community service. That is almost always imposed as part of probation terms, even at the adult level. While restitution is used to compensate the individual victims, community service sentences are used to compensate society. Community service means that as a part of his or her disposition, a youth is required to work a set number of hours doing community improvement work. This work can take many forms, ranging from picking up trash along highways to working shifts in a volunteer location in a community program. In many cases, juvenile judges attempt to fit the community service work to the offense the juvenile committed. For example, juveniles who spray paint graffiti are typically sentenced to graffiti cleanup crews, where they will spend long hours sandblasting graffiti from walls, scrubbing graffiti from road signs, and repainting houses or other structures. In certain cases of vandalism of city property or city buildings, juveniles are sometimes assigned to work crews, repairing the damage or renovating existing city property. So community service, it's a very important alternative sentence, and the goal is to teach the juvenile a lesson and in the process gain some restoration for society in the form of public service. So moving on to some other innovations really quickly. In addition to probation and the wide variety that we've already talked about, there are a multitude of programs for juveniles that exist as an alternatives. Further, they can be directed to sentences of a number of different programs or referred as an alternative to the juvenile court by another juvenile agency. Oftentimes, a sentence to a community correctional program or a facility is part of the probation plan. And there are a number of treatment programs, group programs. Let's start with day treatment programs. They're a type of community correctional facility where the juveniles report during the day for school, vocational, and other treatment programs. The environment of such programs is highly structured and focused on keeping stricter supervision on the juvenile than just through probation alone. Youth and day treatment facilities can live at home, be in foster care, or even be housed in another group home. Day treatment is used as both a front and back end correctional sanction. In some cases, the youth has been released from a secured facility or other treatment facility and is being moved back into the community. In other cases, day treatment is used as a direct sentence by the juvenile court when additional structure and supervision are needed. If a youth is sentenced to day treatment, he or she is most likely supervised under the ISP probation program. We also have, before I skip, the key component or the key benefit of the day programs is providing a stricter form of supervision with cost savings versus secured placement. Foster care is the term used to describe the care and custody of children by families willing to take them into their homes. Some foster families care for several children and some care for a few. Typical foster care is short-term, and the children hope to return to their parents in many instances. In other circumstances, foster care is used for wards of the state raised until adulthood by the foster family. Foster care is also sometimes used for juvenile delinquents in cases where the parents or a juvenile delinquent are either incarcerated or incapable of caring for the juvenile. The juvenile will be placed in foster care. Some foster families specialize in dealing with pre-delinquent and delinquent youths. The placement into foster care can occur while the child is awaiting adjudication from a juvenile court or while the child is on probation. Many juvenile delinquents come from broken homes, and oftentimes the juvenile's family situation is partly responsible for the juvenile's problems. We have group homes. These could be easily classified as a community-based correction or an institutional one. However, since the majority of these facilities are non-secure and operated in the community, it is perhaps more prudent to think of them as a community correctional option. Group homes, as the name implies, are house groups of juveniles who have been adjudicated delinquent. Group homes also care for juveniles sentenced directly from juvenile courts, transitioning juveniles coming out of secured placements prior to them being placed on parole, and we'll talk about that in the next section, and juveniles who have been referred for placement by other agencies of the juvenile justice. Some group homes house only one of these groups. Some house all three. We won't go into those specific details. Generally, on group homes, the facilities are designed to relieve the demand on the regional secure detention facilities to reduce the time and expense of transporting juveniles to and from those facilities and to lower the training school commitment rate in the target judicial districts by providing the courts with a realistic option to involve families. Some group homes house as few as 3 to 4 juveniles, some as many as 50. Regardless of the size, the job of the group home is similar to that of a typical parental household. Juveniles in group homes are expected to follow a structured lifestyle, go to school, work, household chores. In addition, there is often counseling in the form of a group therapy and individual therapy, which is designed to rehabilitate the juvenile. Then lastly, as I'm getting a little bit longer than I wanted to here, rural programs. Real quick, it is what they sound like they are. These are programs that are usually involve 30 to 40 youths, a group of 30 to 40 youths. These programs involve forestry camps or ranches or farms, which provide recreational activities and or work for juveniles. The next section, that's our community treatments. The next section is going to be about our institutional treatment and secured corrections.